Well, I do want to speak on the subject today of the Supreme Court. And I want to address that subject in two ways, looking back and pressing forward. Looking back and pressing forward, safeguarding our constitutional freedoms at the Supreme Court. And so we'll talk in the next few minutes about recent Supreme Court term and really the victories that you and I were all a part of. And then we'll talk about the upcoming Supreme Court term that'll start here in a few short weeks and what we can look to as we continue to contend, continue to defend and safeguard our constitutional freedom at the Supreme Court. There's a little line in Scripture in Galatians chapter 2 where Paul says he gathers with his close friends, and he says he comes to his close friends so that I wanted to be sure that I had not been and am not running my race in vain. I want to be sure that I have not and am not running in vain. So I want to encourage you as we start this topic about the Supreme Court that you have not run in vain. Even as you're here today, it's the cultural conversations that you stand for that has led to many of these victories at the Supreme Court. I want to encourage you here at Eagle 53 that you are not running in vain. When you are running to defend life, running to defend the family and the innocence of children, what has first just been common conversations in your own home, what has been the lifestyle that you've built for your family. Now culture is starting to pick up on that, and that's been vindicated in the last session of the court. And oftentimes it's worth just stopping and saying, yeah, we are doing the right things, making sure we're not doing the right things for the wrong reasons, but we're doing the right things for the right reasons. And so we look back and see in this recent term at the Supreme Court, the victories that we've won. One of the seminal victories that we've won at the Supreme Court is a victory for parental rights, a strong victory for faith and for parental rights, and really for the innocence of children. This is out of the Mahmoud v. Taylor decision. This is a case that came out of the neighboring state of Maryland. It's a decision to preserve the rights of Montgomery County, Maryland parents, preserve their right to be able to opt out their children from being forced to listen to highly sexualized content within their schools. And it's such an incredible victory for parents. And I was able to sit down with two of those parents, Jeff and Slitvana Roman. It was sort of in a setting like this where I guess I should have known who they were, but I didn't. So we sort of got to meet each other just on how average people do around the table. And I got to learn that Jeff sort of helped his father in their family business. Him and his other three brothers work with his dad, and they do a unique thing of refurbishing hotels. They'll buy old hotels, and in sort of a franchise model, they'll refurbish it and then resell it onto the market. And so you can imagine that's really what their family is concerned with, the day-to-day of running a business. Until the Montgomery County decided to introduce highly charged sexual content to 3-year-olds and to 5-year-olds. They would have these books, sort of cartoons, where they'd have these 3 to 5-year-olds go through scavenger hunts for pride parades. It's they go through this cartoon of pride parades and associate what you find with every one of the letters. For L, see if you can find leather at a pride parade or lingerie at a pride parade. These 3 to 5-year-olds being taught this content. So the Montgomery County School District decided to put forward, and so thousands of parents were in uproar. They demanded an opt-out, and initially they got an opt-out. So thousands of parents removed their kids from these teachings. There were Muslims, Eastern Orthodox, Jews, Christians of all faiths, Catholics that said, no, we don't want our children being taught this filth. So much so that Montgomery County doubled down. They realized, oh, all these parents are making an uproar. Let's double down and really communicate this to children. They even placed a rubric within the teacher's curriculum that when the teacher was sharing these things with students, if a student were to tell the teacher, hey, my parents disagree with this, or because of my faith, I shouldn't be exposed to this, the teacher was instructed by the county to tell that student that your parents are wrong, that your parents are being unfair, that your parents are being unkind. That's the official rubric given to teachers as they were wanting to peddle this out to students. What does the Montgomery County do? Well, they double down a second time. They say, we're going to remove the opt-out option. We're not going to allow parents to keep their students away from learning this material. So parents found creative ways of saying, well, if it's going to be taught on this day, we'll just keep our kids at home. What did Montgomery County do? They doubled down again, and they interspersed this material through different language arts and math, as it were, different subjects, in order to make sure that they were pushing this towards kids. And then they doubled down again and didn't even notify parents when this was being taught, so that parents would have no opportunity to resist this content. Well, thankfully, the parents stood firm. The parents took a very bold stand and said that we are not going to allow this to continue, and they brought this case to court. And sort of hearing the arguments, like what would Montgomery County have as a defense for why they needed to teach kids this? Well, they were explicit about it. They said, well, these things, these sort of lifestyles exist in our community. And if these lifestyles exist in our community, for these kids to become good citizens, they need to learn about that. They have to learn about this stuff or else they won't be good citizens. And that's such a false pretense. There's no sense behind that. Just because something exists in the community does not mean that you have to introduce it to children at such an early age, and more so tell them that their parents are wrong if they disagree. One of the delegates at the State House in Annapolis was trying to pass this statewide. He wanted this to be a statewide standard, and he was testifying along the same lines. He said that, well, he's gay married. He says, well, I'm gay married, and kids need to know that my lifestyle exists. To which he was questioned, and it was a strong question. Someone said, well, do you even have kids in the public school system? And before he could answer, I thought to myself, well, it doesn't matter if he has one kid in the public school system or even if he has 100 children. He's not raising my child, right? My kids don't belong to him. He has no authority. There's no legal framework. There's no moral justification. There's no rational reason why he ought to be teaching something to my child that I haven't first been able to expose them to. And there's certainly no argument that you can give to say, I don't want my child to hear this, for him to come in and say, no, the state mandates this. Thankfully, the Supreme Court sided with parents, and we got a comprehensive victory. The one rule that comes out of the Mahmoud decision is that anything that substantially interferes with a parent's ability to communicate religious truths or to train up their child's education, that runs afoul to the Constitution. And it's a massive, massive victory that they didn't even rest just on this one fact pattern, but they expanded it to anything that substantially interferes with that parent's right to communicate truth to their kids. You know, we should always be fighting for the interest of our children. We should always be fighting for the innocence of our children, and not just when they walk through the schoolhouse gates, but also what they engage with on a day-to-day basis. And the second case that I'll present sort of outlines that. Another victory that came out preserving the innocence of children. You know, children will watch upwards of 30,000 hours of content before they turn 18. And there's so much that they have access to on their tablets and their iPhones and their cellular devices. So Texas passed a law to stop the pornographic industry from getting to kids' minds through their tablets. This is a law that targeted websites. It's an incredible law that Texas passed that targeted websites that are built primarily or exclusively on pornographic content. These are the purveyors of pornography. And, you know, pornography used to be regulated to the small, seedy part of town that you'd never drive through. Or if it was on a newsstand at a convenience store, it had to be covered up. But at this point, it is accessible in a child's hands, where the numbers are staggering. Over 80% of young boys between the ages of 6th grade to 12th grade, over 80% said they've viewed pornography either on their own phone or a peer's phone. Over 64% of girls in that same age category have said the same. You know, if any of this content was handed to a child, the person giving that child that content physically would be arrested. If a store were to be selling this to a child, that store would be shut down right away. But this filth is being sent to children via their cell phones. Texas stood up, and 17 other states have stood alongside Texas and passed this law, and it was challenged by the purveyors of the pornography industry. And the court came down on the side of Texas, and they said, you know, it's very basic. Just as government can regulate certain things and make age verification necessary for the consumption of tobacco or alcohol or even rental cars, it's in that same concept that they can regulate certain things for ages, that they can have simple markers to determine, yeah, this person is of age or underage, and they shouldn't be participating in whatever the vice is or whatever the subject matter is. And so the court had a very simple decision, and they erred on the side of Texas. And it's an incredible victory. We hope that it leads to a stronger cultural response. You know, what God calls perverse content, we have to be bold and call it evil. Thankfully, Texas has filled in the gap in that sense. They want to protect the innocence of children. And by doing so, we can continue to chip away at this industry that has such a strong hold over this culture. You know, we haven't run in vain when we look back at these victories for the innocence of children, protecting their innocent minds. This phrase, "I have not run in vain," also compels us to look back to another fight that all of you have been a part of for so long, the fight for life, the fight to preserve and to protect life within the womb, to defend the innocence of babies within the womb. And an incredible case came out of this term of the Supreme Court, particularly from the state of South Carolina. It and several other states are now able to defund Planned Parenthood. These states have won a victory, an incredible victory, a 6-3 victory in the Medina versus Planned Parenthood case, where they can defund Planned Parenthood. The High Court ruled that South Carolina is able to withhold its Medicaid funds from Planned Parenthood. And the court said in a very simple way that a state is able to determine and choose who their providers are that receive Medicaid funds. It's not an endless right. It's not an endless delivery of funds. They can choose who qualifies. It's states themselves that can say, well, this organization is not ethical. It's not lawful medical care. We do not want to fund them. And in that way, South Carolina was able to boldly stand for life. They refused to funnel Medicaid dollars to Planned Parenthood. Well, Planned Parenthood obviously ran to court, and that's why we got this case. They ran to court and said, hey, we're a qualified provider. We're a qualified provider. Medicaid Act applies to us. It should protect us. But the Supreme Court says no. The Supreme Court says the providers that qualify is what the state deems qualified. And they must be qualified according to South Carolina based on their moral and their legal standing. And that Planned Parenthood is not qualified. Planned Parenthood is not qualified. Planned Parenthood is not qualified because they've been implicated in so many illegal acts over the years. Planned Parenthood is not qualified because undercover investigations done by Sandra Merritt and done by David Daleiden has exposed this dark, shadowy trade where they'll abort babies and barter and negotiate and sell baby body parts. Planned Parenthood is not qualified. They are not qualified because they participate in and they enable human trafficking. Planned Parenthood is not qualified. They are not qualified because they spend millions of dollars on abortion advertisement campaigns. Planned Parenthood is not qualified because they buy advertisements that try to create a narrative saying that babies are a burden and that they're inconvenient. Planned Parenthood is not qualified because they make a profit over women in desperate situations. And the reason why South Carolina said, not with our dollars, not with our state, is because Planned Parenthood is not qualified. And we got from the court, we also got during the reconciliation fight here in Congress, a bold statement saying that we don't have to give our taxpayer dollars to go fund death, that our convictions are not for sale, that our resources should not be used for murder, that life will not be trampled upon, especially by those that are profiting from death. South Carolina led the way in that regard, and the Supreme Court has affirmed that truth. It's a truth that you all have been fighting for, that life is worth defending, and that the American people will not be forced to pay for their destruction. I have not run in vain. When you see those victories coming about, you can say that I have not run in vain. As Jay mentioned, another victory that came out of the court is in this fight against the transgender ideology out of the state of Tennessee, it along with 27 other states. And you all have been in the fight against the LGBT agenda from its outset. For the past 5 to 10 years, when it has really ramped up, we've seen this onslaught come from media and from social media and from celebrity culture and from TikTok challenges. And really, it's just the spirit of the times that has brought about this onslaught of the transgender ideology. It's this deranged ideology, as it was so eloquently presented, this ideology that says that a young man can go in and physically castrate himself and remove perfectly working body parts, or a young girl can cut off certain body parts and attach other body parts, and somehow that makes them different from how they were, undergoing irreversible surgeries. Well, there's a reality that the court was faced with, and that reality that was passed through this Tennessee law is that these kids can never truly consent to this type of surgery. They can never truly have informed consent. They can never really process the lifelong implications of what it looks like 10 years down the road or 20 years down the road when they may want to be parents themselves, but they've sterilized themselves because they were lied to. Not to mention that 100% of the time, these surgeries fail. 100% of the time, these surgeries will fail because you cannot change the way that God has made you. It's for those reasons. It's for all these reasons that the state of Tennessee and 27 other states passed a law banning this practice, and the Supreme Court sided with the state of Tennessee. It's because 90% of young men that go through gender dysphoria, when they reach the age of majority, or even when they just go through puberty, those ideas dissipate if they have proper counseling, if they work through the heart of the issue. It's for all those reasons. The fact that this is medical experiments, the fact that Tennessee has the right to protect the innocent ones, for all those reasons that we have this strong victory from the court that is very basic, that there is male and female, and it is really your influence that has brought us to this point. The court was able to ride on the coattails of a culture that saw the common sense of this idea, because you would not stop talking about it, bringing us to this point. So it's an incredible victory. We're able to look back at all these victories because you weren't afraid to speak up consistently and with wisdom, and saying that, hey, we're going to apply this right where we live. That's how cases make their way up to the Supreme Court. It's because these parents stood firm. It's because these cases were brought by organizations that litigated them in court. It's because truth is still worth defending, even when it's costly. It's because the court has recognized what you and I know deep down, that no government can ever replace mom or dad. It's because innocence should be protected. It's because life should be preserved in the womb that we have these victories. And so, yes, have we had these victories? Have we run the right race? Well, when I see the rights of religion and parenting being promoted through the Mahmoud decision, yes, I can say that we've won and run our race the right way. When I see that we're taking care of the little eyes and what they see, or taking care of the little ears and what they hear, then yes, we have run the race the right way. When I see that Planned Parenthood is being defunded, we have run a good race. When I see the falsehoods of the transgender ideology crumble under the fact that we're going to continue to build up strong boys and we're going to continue to build up strong girls, then yes, we can say that we have not been running our race in vain. When I see our faith still being lived out with courage and conviction, when I see truth still being treasured despite the trials, despite all the testing, when I see our beliefs still boldly fighting and being able to break through any backlash, when I see our hearts that are united, still holy, still holding out hope, still taking the fight to even these hostile legislative halls, when I see you all who are sanctified and saviors really of your state and this republic, when I see you continuing to stand strong and remain steady, being so ready for the next fight, I know this to be true, that we have not run our race in vain. When I see the now immortal icon of integrity, Charlie Kirk, And I see how his influence and his impact to inspire the next generation is immeasurable. I know this to be true, that Charlie Kirk did not run his race in vain. He did not run his race in vain. And so we look back on this past year and the past few years, and we see that we have not run out of bounds. We have not grown weary. We have not fallen behind. We can look back and see those victories, but we can also look ahead. We can look ahead to the next few months and the next few weeks where the Supreme Court are going to reconvene the next term and the fight that lies ahead. We're still going to have to deliberate the transgender ideology in front of the court. There's a case coming from West Virginia where the sports issue will be brought forward, where these young girls are basically saying, hey, I only want to be playing sports against my peers, other girls. I don't want to be forced to be playing sports against biological males. It's a great case that we have the opportunity to make that bold statement for male and female once again. Make no mistake, it's not just about sports. This case surrounds sports, but it's not merely about sports. It's about truth. It's about fairness. It's about preserving the innocence of our children. It's about protecting our young girls. And so we'll have that opportunity in front of the court to make that case once again. Also, this term comes a case from Colorado. It's a very basic and simple case that deals with reparative therapy or counseling, the ability for someone to sit down and have someone help them through tough subjects, have them help through unwanted same-sex attraction. It's a case that seeks to restore the simple conversation that occurs between a client and a counselor. If someone is struggling with same-sex attraction, and you know this well, perhaps you have folks in your family or certain folks that you are around that have entered the LGBT lifestyle, and some of them have done so out of brokenness, or perhaps it was abuse or unmet longings. Perhaps they had a failure to identify with one parent or another. Whatever the situation is, there's some wound that has been left unhealed. But when they're able to sit down with a counselor, when they can talk through these issues, they are heard and they are helped. And you see these feelings sort of dissipate. Healing can come through these conversations. Freedom can be found. They can be rescued from the LGBT lifestyle. Well, there are a number of states that has banned even that counseling, even that reparative therapy that helps make people whole. But the Supreme Court in this next term will take up this question. This case is personal to me because I was raised by a psychologist. My dad has been a clinical psychologist for 40 years. And during the summer months when I was off of school, I sort of acted as his front door clerk. I would sit in the front office and I'd usher people back to his room. And you'd see folks come in for their therapy session and they'd sort of be hunched over and they'd sort of be leaning forward. And you could see on their countenance that there was hurt, that there was a burden that they were carrying. And after the 45 minutes to an hour, they'd walk out and you'd see a visible difference. Their countenance would be lifted. They would have a different walk about them. They'd have their hope restored. And that's what counseling seeks to do, just simply work a person through their hurt and provide healing. That's what this case seeks to protect. It's the right of young men and young women to hear truth and to find freedom. There's one more case that I'll mention that we're going to anticipate in this next term. This is a case that strikes at the very heart of religious organizations and faith-based organizations, and their right to hire or fire people based on the organization's mission. And we've seen in the past 10 years or so these sort of sting operations where an individual knows that they hate their Heritage Foundation, or they hate an FRC, or they hate a church-based organization. They're like, well, I want to take that organization down. And so they get hired on false pretenses and they lie on the contract. They, reject the organization's statement of faith. They openly defy in their behavior, living in a manner that's against the organization. And so when the organization finds out, naturally they fire or they terminate that person. Well, that person has turned around and has sued these organizations in order to try to either rack up the damages against the organization or shut it down altogether. Well, in this next session, we'll have the opportunity to really address the fact that religious organizations can hire and fire based on their mission. Think of Eagle Forum and what it took to put this event together. You know, the individuals that put the name tags together or made the phone calls or the flight arrangements and the hotel arrangements and put all the agenda together. Everyone is working towards this mission. And Eagle Forum has the right to hire and fire based on folks that will advance the mission. Catholic Charities, the named client in this case, has the right to hire and fire based on those that will accompany the mission going forward. And so that's what is going to be at stake in this next session. You know, all these things that I mentioned, all these things that we're fighting for in the days ahead. The days ahead will let us know that it's the right to ultimately believe a certain way in our heart, to be convicted around these tables about something that actually matters, but also go out in the public square and express that faith, express that truth, to be able to defend those beliefs, to be able to once again protect the innocent, to be able to resist the progressive agenda and really resist any agenda that cuts against God's design. And so we will stand firm, we'll stand strong on these truths, we'll stand strong on the strong constitutional arguments that we can make, the principles that this very organization for decades has upheld. And so I do want to encourage you, as dark as today seems, there's certainly brighter days ahead. And I want to encourage you, this centennial crowd here, and the fight that you're in, the legacy that you represent here today, it actually matters. The labor that you have already exerted in the past days and that you'll continue to exert, that will be rewarded. It will be demonstrably manifest, all the time and effort that you put just for the fight for truth. Your work will go out throughout history. I know that to be true because I know your organization. I know your leader very well. I know your president, Chris, very well. As she mentioned, I've sat down with her and done dozens and dozens of TV interviews and have sat on panels with her. And in real time, I can see how she navigates and helps develop lasting policies. And she puts these ideas forward in real time, even on the tough issues. And I was telling my wife the other day that I've probably had maybe 100 or so recorded conversations with Chris, and I can't think of a single time that I've disagreed with her, not a single time that I've disagreed with her. And even if I did disagree with her, I'm not disagreeing with Chris, right? I'm not going to get that wrong. But I know your organization. I know who's at the helm of this leadership. It's someone who has that conviction. When Chris says something or believes something, you can take that to the bank. That's the future of Eagle Forum. I know that because I know Tabitha really well. I've walked the hallways of Congress with Tabitha, and I've seen her engage with the legislators and these administration staff. I've seen her courage and her poise and the lasting impact that she's had on Congress. I know the heart of this organization. I know the tenacity of the folks in this room, just the time that we got sitting around this table, the conviction that is flowing from this room. And so I do want to encourage you to keep up the fight. Double down on your convictions. Recognize, yes, your dependence on God, but never, never, never let up in your fight for what is right. Open the door for others to come in and see this is what righteous living looks like. This is what good living looks like for the right reasons. And then chart a course for your life, for your family's life, for your community, and for this nation. And you will soon see that, yes, in this 53rd Council, in the 54th Council, in the 55th Council, in the 100th Eagle Council, all the fruit that is borne out by the efforts that you've placed on these issues. And in that way, on that day, you will have not and you will not run in vain. God bless you all.